can you please look up this site?
See if we can figure out something.
Accessibility is clear. We're good to go.
We also have two of our witnesses here as well if we need them.
They got their witnesses. They're not gonna take testimony.
That's eight.
Well, hey, we have them here just in case, no
We'll
worries.
save it. It's okay. We can save it.
I have text messages. And
It's okay. No, there's a time and a place for that, and it'll be addressed in the moment.
Okay.
They did Zoom meetings with the witnesses and everything. No, they don't. That's what I'm saying. Well, they during COVID, they could Zoom testimony. But this is like the first pretrial. Nothing. The judge has to sit down for pretrial 60, 90 days from now. Since they're out of the house, if they were still in the house.
Just want you to know we can hear you. You're not on mute.
Yeah, we can hear you.
Yeah.
Everyone can hear you.
Yes, Tom. Mr. Ellis, we can hear everything you're saying.
Good.
Miss, and I apologize if I'm mispronouncing your name, Abood Carroll. Can I ask, is this meeting being recorded?
I'm not with the court. I'm on another case. So I think we're all just kind of queuing up right now for all the hearings that are in front of the judge.
James Summonek versus Travis Ockerman.
Attorney Tom Ellis, appearing on behalf of the plaintiff, Your Honor.
Travis Ockerman.
It's Ockerman and Meltzer.
Yes, Your Honor, that's correct. You have Travis Ockerman and Nikki Meltzer representing themselves.
Okay, very good. All right. What is the claim in this case? How much is owing, inclusive of cost, Mr. Ellis?
According to our complaint, Your Honor, we asked for $5,743.80, but we are giving him credit for some propane that's in the tank. So he's going to owe approximately $1,150 less.
Your Honor, may I ask, this is news to me. This would be news
Okay,
to
hold
me.
on, folks. Hold on a moment. I need, Mr. Ellis, I need to know what's owing or what plaintiffs are claiming are owing on the account as of today, including court cost.
$4,750 approximately.
That approximately figure again. All
Your
right.
Honor, may I ask a question?
Hey, Steve.
Sure.
We, so on the propane tanks, we have evidence and pictures of the readings and the levels of the tanks and can quantify the sum down to the amount owed based on what Mr. Samanak had paid per gallon. The current levels of the propane as of when we left the property on April 30th were, there was just under 60% in one tank. There was just under 70% in another. So the full usage of the propane did not take place. And I do have concerns that the amount of money they're sharing does not quantifiably add up to what would be owed in relation to that per gallon rate.
In addition to the rent that they're asking us to pay, we've already paid our rent per an agreement with Mr. Samanak for a prorated rate of rent for February, March, and April, as long as we're out by the end of April.
And this was on the basis of a violation of our lease agreement due to non-repair of, and I have evidence to show pictures of a
Okay.
history.
All right. All right. Hold
Yes,
on,
sir.
a moment, folks.
Yes, sir.
This is the first
Yes, sir.
hearing. Okay. All right. Take a breath. All
Yes,
right.
sir.
Because I wasn't there and you're giving me a lot of information. Okay.
Yes, sir.
So
Your Honor, it's a lot.
Counsel, as I'm looking at the complaint, there's $3,023.80 for propane.
That is correct, Your Honor, but we'll give
So
him.
I guess here's what I'm asking. What I'm asking is, what is the rental amount that's due? And then what's due for propane?
$2,420 is owed in rent. And the
Two
propane-
thousand two.
What is propane
2,240
Yes,
Gas
sir.
stove.
for rent. Okay. And then, so if I were to subtract basically the 4750 approximately that you gave me, the rest of that is propane
Yes, in our complaint,
and court costs. All right, fine. Then it's just propane. We'll worry about the court costs later. All right. So
$2,182 is owing for propane.
$2,180 for propane.
Yes.
$1,400 has been paid to Mr. Samanak. I can confirm 500 in January, 500 in March.
Sir.
Yes, sir. I
Sir.
apologize. Yes, sir.
Thank you. All right. What payments have you recently received? Has your client recently received, Mr. Ellis?
Originally, approximately 6 weeks ago, my client agreed to reduce the rent if they pay up the back propane bill. And payments were made of about $1,400. But that did not pay up the total back propane bill. And so the defendants are not entitled to any rent reduction because they didn't follow the agreement.
Your Honor, may I make a statement here? At no point in time was this.
Have I
agreement-
been able to stop you? But go ahead.
Sorry, I'm so sorry, Your Honor. At no point in time was this agreement ever predicated on the payment of the propane. It literally, in any communications with Mr. Stamenak, that was not conveyed. I have interactions. His son-in-law, Harvey Proctor, actually came to pick up the money for this prorated rent. And I have text messages showcasing the process of, hey, this individual is going to come over to collect this money.
All right, so folks, let me just ask you this. You're currently out of the property.
Yes, Your Honor, we are, as of April 30th.
Okay, so possession isn't an issue. The issue is how much rent's owed and how much of that is owed for propane,
Correct.
right?
Yes, Your Honor.
Can I ask, was there a written lease or written agreement regarding the propane?
Yes.
In the lease, it does say that the tenants would need to pay the full balance of the propane by December 31st of the year. And we talked to Mr. Stamenak, since we will be leaving in April and not the end of the year, that we would check the propane levels once we left the property and pay him the balance that we used for the propane from January 1st to April 30th.
We also have witnesses. Mr. Stamenak has visits to my.
You know what?
Yes, sir.
You can keep talking, but I don't know why it is. I understand her a whole lot better than I understand you.
That's totally fine. I'll let her do a lot of the talking.
What she said to me makes absolute perfect sense. So, I mean, it makes sense in terms of something that could have happened. I don't know if it did or not, but I get it.
Yes, sir. Yes,
But
sir.
my bigger problem is I don't have, and it was not filed with this. I don't have the written agreement that is it Meltzer?
Yes,
Meltzer?
Meltzer.
I don't have the written agreement that she's referring to.
So it's
That
in
was not filed with the court.
apologies. It's in their original lease agreement that we signed with Mr. Stamenak back in
No.
December.
It's okay. It's okay that I don't. I'm just letting the parties know. No, I don't have that. I'm taking your word for what it says, but I just don't have it.
Yes, sir.
Yes, Your Honor.
All right.
I'm happy to read that to you if you need to.
Okay. All right. So we're not going to be able to resolve this today. So obviously there's a dispute between the parties as to what this propane bill is. And then let me ask you this, outside of the propane, do you believe that you owe the amount of rent?
No,
No.
sir. Due to the agreement that Mr. Stamenak and I and Travis made
Sorry
on the phone
about the sniff.
in January 19th
It
of
just blew my nose.
2024, he agreed, since he has violated our lease by allowing multiple people onto our property without our knowledge,
In violation.
and after we have asked not to have that happen in violation to our rental agreement, section 9 of that, I know you don't have it, I apologize,
It's okay.
that technically the only people allowed on our property is the landlord or people doing repairs. It does not state that what we were living on was a working farm and that men will be in and out of our property multiple times a day. That was never disclosed to us. We asked him very kindly multiple times. This has started.
Okay. I'm going to stop you. I'm going to stop you there because you're probably going to explain that to me again. But here's what I'm going to do, folks. Possession isn't an issue. It looks, quite frankly, like this is just going to be math. So in terms of setting it up, I'll hear everybody's story. But what I'm going to do is I'm going to set this for a final settlement conference for May 14th, 2024, 9 a.m.
Okay.
That proceeding will be in person at the courthouse. Bring all of your paperwork and everything so that I can look at it and I can refer to the provisions. You said something, ma'am? I'm sorry.
I'm so sorry. Are we allowed to bring witnesses to this?
Okay, what are they going to be witnesses of?
So his parents are good friends with Mr. Stamenak, and he has even stated that we were paid up on our rent. They have text messages between them paying the propane balance of $1,400.
Okay, look. Here's what I'm going to do. You can bring whoever you'd like. Whether or not I'll be able to hear from them at that time, I don't know.
Understood.
But as between the parties, I've got to get everybody to agree on what issues we would be litigating. So it may be from this final settlement conference, I will set a trial date at a later time where I'll hear the testimony. All right, but you can bring whoever you'd like. I suggest that you make sure to bring all of the documentation that the parties have regarding everything. Well, not everything, but anything relevant.
We have a
May
full.
14th. Pardon?
We have printed copies for you, and we also have an iCloud link if you would like that at any time.
Okay, all right. You can always send it to the court for filing with the court, and then I'll take a look at it at some. Okay,
Okay, thank you, Judge.
Mr. Ellis, anything else?
Nothing further. Thank you.
All right, we'll see everybody on the 14th. Thank you.
Thank you.
District Court for County of Washington, State of Michigan, is now in session. All those having business before the court are near, the Honorable Judge J. Cedric Simpson presiding.
You may be seated. Okay. And. All right. Who's on this? This is Mr. Fink is still, and
Do you want me to go see if Mr. Fink is available?
he's still in a hearing. I was hoping he would have notified you that he's in a hearing and will be in a hearing before Judge Barr virtually. So. Tell you,
No, and I have a Judge Barr hearing at 10.
at what time? 10 o'clock? He'll wait. Just saying. What? At 10? Yeah, in a few. If we don't, we'll break and try to we'll figure out something.
Thank you.
All right. Lou's gonna have to stay with me all day. Only because it makes me happy. Court does call the case of James Samalak versus Travis Ockerman and Nikki Meltzer. I think we may need that table, folks. We may need the table. State your appearances, please.
For the record, Tom Ellis, appearing on behalf of the plaintiff,
Your name?
Travis Ockerman.
Thank you, Meltzer.
Thank you. All right. Take time for the adjourned trial date. Are we ready to proceed? You received a copy of the response to the complaint?
I just received it this morning, but it's what it is.
All right. And okay, you may begin.
This time I called Plaintiff James Sammonick.
All right. You're waiving opening.
Yes, just to expedite the matter, Your Honor.
It's too late for that, but you understand he's waiving his opening statement and he will just proceed into testimony, and that's fine with you folks. Did you wish to give an opening statement? Tell me. It won't be necessary. Sir, did you need, I think last time you needed hearing equipment? Okay,
Thank you for asking. I remember to get my hearing aids today.
so you're good?
Yes.
All right. Let's bring him forward and have him sworn.
Before you take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Go ahead and have a seat. State and spell your first and last name.
My name is James Sammonick. J-A-M-E-S, S-A-M-O-N-K.
All right, thank you. You may inquire.
I have received, Mr. Sammonick, I showed you some documents there. We'll get to those in just a minute. Do you own a house or farmland on Austin Road in Manchester?
Yes,
And is there a rental house on that land?
yes,
Did you at one time enter into a rental agreement with the defendants?
yes.
I believe the court has a copy of the lease agreement.
I have a copy of the lease agreement that's dated December 27, 2022.
That is correct. What was the rental agreement for that house?
We rent the house and the attached garage. No, none of the other buildings. And we paid it to be $1,200 a month. And I had purchased the propane and they were to reimburse me for the propane in the tanks. And the tanks we refilled in the winter and summer. The cheapest rate is a summer fill. And they would pay for that after they were filled.
And when they moved in at the end of December, did you go out and read the capacity of the tanks at that time?
On the day they went, well, actually, January 1st, I believe. I think Travis went with me, but I'm not positive on that. Read the tanks, wrote it down, and calculated how many gallons were in each tank.
And I show you an exhibit there. I believe it's marked exhibit number 18.
Yes.
And I believe I gave you a copy of that last time you were here. Travis?
You talking about your photos?
No, the copy of the calculations for the propane.
And your. Are you referencing this handwritten?
Yes. So what was your understanding with the defendants as to the propane tanks and the cost of that propane?
We We read the gauges on, there's 3 tanks there, 2 1,000s and 1 500. We read the gauges, calculated the gallons. The price was set when I bought the propane in summer of 22. Travis and I read the tank and we calculated it. And I told them they didn't have to pay it immediately, that they would pay it over some period of time, like maybe 300 a month. I'm not sure the number was given. And it turns out they didn't pay anything on it.
Okay,
The tanks were filled again in the summer of 23.
so how much money is owing to you for propane that was used by the tenants?
Well, after calculating both what was in and adjusting for what's left in the tanks when they moved out, and giving credit for the 3 payments that his mother and stepfather made, $1,889.02 is still owed.
How much of that is the amount of propane that was in the tank initially?
Usually on the front page, 1,480 gallons were in the tanks when they moved in.
And how much was in tanks when they moved out?
915 gallons was left in the tanks when they moved out.
So more was there. Where is that calculation?
On the front page.
Front page, what are you referring to? I don't.
Your Honor, I would move for the admission of exhibit number
This is number 18.
18, which is the calculations on the propane tank.
You have a copy of this? You do. Handwritten copy. When was, well, sir, when was this calculation done? I mean, when was this written?
That page I wrote roughly 3 weeks ago. I just copied everything that we've had in our file, compiled it into one list.
In what file are you talking about?
Sorry,
In what file?
I filed my records that I had.
So if I take this, it says August 12, 2022, filled 3 tanks to 85%. Where's the record that backs that up?
There's a copy of the bill on in the and there's the Green Energy is the name of the company I bought from. There's a copy of the bill, one there for 22, and there's another one for filling again in 23.
Go ahead, Ken.
Was there any money owing to you for electricity?
Yes,
And you have an exhibit there, I believe it's exhibit number 19.
number 19, correct.
And what does that exhibit show?
Travis, they moved in. I didn't put the bill in their name, and I don't think I was able to, but I didn't do it, and they didn't do it either. And the bill was sent to me. We have our electric bills on auto pay, with Consumer Energy bills on auto pay, and I did not catch it until payment was made. By the time I caught it, we'd already paid the electric bill for January, February, March, and April, possibly May. I contacted the Consumers Energy and asked them to put it in Travis's name. I'm not sure if I had to do it or Travis did it. But anyway, so then I gave them a bill at that time for 5 months that I paid. And it's $170 in
What 5 months were those?
January, February, March, April, and May. And Travis had cleaned up the yard there because of a storm and wanted to be paid for it. And we agreed on $170. So we discounted that bill by $170. He paid $600 of the remaining $700. So it left $100 still owing. About a month and a half later, I got either a phone call or a letter from the collection agency wanting to know when I was going to pay my electric bill. I did not realize that there was another month had been charged against me. I did not receive a bill on it. And I had stopped the auto pay on it, it did not get paid. So then I paid the bill. I believe I told Travis about it, maybe I didn't, I don't remember on that for sure. So there's total, that last bill for June was $193.66. So together, the total electric bill still owing is $293.66.
And that exhibit you have there has copies of those electric bills.
Copies of all 6 electric bills,
They show the service address and the dates of the service.
yes.
I have no further questions on this exhibit. I move for its admission.
And you just see it.
I think you have a copy of that.
Yes, you may approach my bench.
Yep.
It's not the way it works here, Council. You asked to approach. This front sheet, sir, when was this created? This handwritten sheet?
Just before our last hearing, roughly 3 weeks ago. There again, I prepared it off my notes in my record.
Where did this consumer energy bill, where did these come from?
I called the Consumers Energy and asked them to send a copy of the bills that paid by. So actually, the Pony Farms LLC is the LLC that owns that property. I'm the owner, my wife and I are the owners.
Well, okay. And so they sent these to you?
Email, yes.
Was there ever an agreement with you and the defendants in regards to reducing the rent if they paid the propane?
Yes, in January, I believe. We had a kind of a one-way heated discussion on the phone, and in a long story short, I agreed to a lesser rent. And they were going to move out by May 1st. Contingent on, prior to that, his mother had told me that she would pay, and John would pay the propane bill. And they did pay 500 in December, 500 in January, 500 in February. Then the payment stopped. As far as I'm concerned, the agreement was void after that because it was contingent on continuing to get the propane paid.
So what was the agreement?
The agreement that I would allow them to pay half rent for 4 months. And they understand they would be out by the 1st of May. It's contingent on, and the mother had already said that she would pay the propane bill. And they did, like I said, they did make 3 payments.
How much were they supposed to make?
They were going to pay what they could afford, 500 or so. It was not an exact amount until it was paid off. The first month they paid 500, December, January they paid 500, February they paid 400.
Until what was paid off?
The propane bill,
They know what that bill was?
yes.
How did they know what the bill was?
I'm sure I told them to show it.
Okay. So
And-
what did you show them, I guess, is what I'm trying to figure out.
Well, I don't have the paper in front of me, but it'd be a calculation like you have on the front page of our exhibit of the propane that was there when they moved in. Propane that was there when they,
I get you, but was there a document that you showed them that told them what they should pay?
can't say for sure, I assume it was. Yeah, I'm sure they would ask for it.
Did you know the amount that was owing?
At that time, we did not know what was going to be left in the tanks when they moved out. But the amount that was in there when they moved in and the amount that was added in August or the summer of 23, those totals were there. And there was going to be a correction made. An adjustment.
Okay, but here's my question. How would they know what to pay?
The original bill wasn't paid of approximately $2,800.
Okay.
That wasn't paid. So there's at least that much had to be paid. And then the refill in the bank was approximately $1,700 in the summer.
Would you tell them that's never happening again? Okay, so trying to understand this. There's an agreement that they will pay. Their parents are going to help them pay, right?
Yes.
Okay. Part of this agreement is that their rent would be 50%. Correct?
Also pay on the propane capital.
Well, but part of the agreement is that the rent is 50%. The other part of that is that they will pay the propane. Right?
Yes.
But how do I know that they defaulted on that if I don't know the amount they were to pay?
Mr. Samanek, how much money was owing for propane in January when you talked to them about this? Would you like to review your exhibit?
Yes.
Okay, so how do they know that?
I believe I showed them and told them. They have copies, or had copies of these invoices.
All right.
Is there any discussion at any time about doing painting in the house?
And I'm not real clear on this, just prior to when they signed the lease, they would have.
What did you say?
With our lease, and I'm okay with it.
Here I show you a list of exhibits with our pictures of your house. Some of those exhibits show the paint job that they did in your house,
Yes,
and you took those pictures.
I did,
And do they accurately reflect the condition of your house?
yes. These pictures were taken after I believe the day after they moved out.
Okay. I would move for the admission of the exhibits there, the pictures. I believe the defense have copies of those pictures.
Including the ones that are online for
Okay.
anybody interested in renting houses.
May I approach the bench and give the exhibits of the pictures?
Yes. What exhibit number is this?
Pardon me?
What exhibit numbers?
The exhibit numbers are exhibit 1 through, they're not consecutive numbers. Exhibit 1, 2, 3, 4, 5, 6, 7, 8, 9, and 17.
So 1 through 9 in exhibit 17.
Yes, sir.
All right.
Do those pictures show the walls of various colors at one time?
Picture shows partial paint jobs of several doors and walls that somebody had taken a roller and put a dark blue color or dark color, a couple swipes with probably to test the color, several places, and then it was never complete. And another picture shows a room that's painted some color of red, that I know I did not approve. And I did not approve the dark blue color.
Did you repaint that house or those rooms which they put that paint on? Or did you hire somebody to do
The
it?
job was being done, it's not totally done yet.
How much money have you spent on the repainting?
Over $1,700 for paint and labor, and it's not done.
Who's doing the painting?
And they brought Reese and his wife Sherry Reese.
Is there a bill?
I have an estimate for $1,700, and that's what it is, it's an estimate. I have another estimate.
Where's the estimate?
Sorry.
Do you have that estimate with you here? Could you mark this as claims exhibit, I believe, number 19?
What provision is plaintiff relying on regarding the painting?
In the complaint
No, in the lease.
or damage to the premise?
Sir, was it gonna be painted anyway? I mean, after they moved out, wouldn't you repaint before you rented?
Thoroughly. They were here. Year and 3 months.
Was there difficulty in repainting because of the dark colors?
Yes, it required 3 coats over the.
Did you do the painting?
I did not do it myself.
Well, how is he gonna testify to that, counsel?
Were you present to see what was going on?
I was there every day that they were there. I watched what they were doing. Physically not able to do all that work.
Right, I get that, but are the painters gonna be here testify?
No, they're not.
Because all of this is hearsay.
Well, he can testify as the amount of money he's paying to have something done.
Maybe. But he's also saying he's got a contract and the necessity of it being done. They have a right to challenge. I don't have the painters here. I mean, they're the ones telling him that's what needs to be done. Or am I missing something?
He's relying upon his knowledge of what paint looks good and what paint doesn't look good and how he can solve the
I
problem.
don't even know what that means. Somebody is coming in and doing the work. He's talking about what they're doing and the necessity to do that. That's all hearsay, unless I have them here, because they're the ones doing it.
I believe Okay, we'll move on then.
Go ahead.
Did Travis ever tell you there was any problems with that house? Any repairs need to be made?
Yes.
What did he tell you and when?
Specifically the bathtub,
What sort of bathtub?
old cast iron bathtub. That appears to have been paint job put on it years ago, and parts of it were chipping off near the drain.
And what did Travis say about the bathtub?
Wanted to do something about it, and along the edge of the bathtub on the shower enclosure, there's a part that's coming apart. That I do not remember that happening. I did not remember seeing it prior to that. Travis pointed that out also.
Did the epoxy paint that was peeling on the bottom of that bathtub affect the bathtub use at all?
I don't think so.
Was there also other bathing facilities in that house?
The new bathroom was put in approximately a year before they moved in. Ceramic tile shower, toilet, and sink. So there was another place to take a shower.
Do some of your pictures show those,
Yes,
the bathtub and the other ceramic shower?
yes,
And you took these pictures?
yes,
And these are exhibits 10, 11, 12, 13, 14, 15, and 16, is that correct?
yes. Some of them are the bathrooms, some is the yard, the driveway.
I show you two pictures there, I believe that's exhibit 19 and 13. What do they show?
Number 13 shows the old bathtub and shows the inside around the drain. Number 19 shows the new ceramic tile shower
And
and the new bathroom.
picture 16?
It shows a surround around the shower in the old bathtub, where it's become a little attached from the wall.
I would move for the exhibit of 13, 14, and 16. My approach.
Any objection? Yes.
Did they ever tell you about any other repairs that need to be done to that house?
Not that I can remember.
When they moved in, was there any discussion about the house and the barns and the farmland surrounding that house?
Yes, I told them that I have a farmer that farms the land. He will be going through the driveway, coming in and out. We have irrigation on that farm, and especially in the summer months, he would be in there pretty frequently. My son has equipment stored in some of the buildings, and another neighbor has hay stored in some of the buildings, and I have tractors stored in some of the buildings. And I told Travis that what he has is the use of the house and the detached garage, not the other.
When these exhibits here in front of you are listed as exhibits 10, 11, 12, and 15, what do they show?
Shows the farm property, shows the driveways, shows the buildings. Shows the shows where my farmers have to come through the driveway there in between the house and the buildings to get to the back of the farm. And the driveway that goes from the main driveway up to the garage is a relatively short driveway.
Did Travis ever complain about anybody going in the driveway?
Yes.
What did he say?
He felt that it was a private driveway for him only. But he didn't understand that it was a farm driveway. My son actually has been in and out of there several times. My farmers at farmland have been in and out several times. The man that puts hay in the barn and got to the point where Travis insisted on having call ahead notice, make an appointment to come through the driveway. So trying to cooperate and keep peace in the neighborhood, we would call it as often as we could. We just didn't try and keep peace.
I would move for the admission then of these exhibits, Your Honor. The defendant has copies of them.
Any objection?
No objection.
Those are admitted.
Did Travis ever give you a forwarding address of where he was moving?
Not right.
Okay, did he ever give you a forwarding address?
I assume he moved in with his mother and stepfather.
Not the question. Did he give you a forwarding address?
No.
Okay.
So in summary then, what money is owed to you?
Months rent.
Of $1,200 per month.
What months are those for?
March and April. $293.66 for the electric bill. $1,889.02 for the Goble.
I'm gonna go back to a question that I had that I didn't get an answer to. What lease provision is he relying upon regarding the painting? 7? One that plaintiff's relying upon, counsel? Paragraph 7?
Talking about paragraph 7 of the lease, which provides,
That's about improvements and alterations to the premises.
yes.
Normally, that's applicable to fixtures. What provides that to plain? I don't. Well, I'll let you make your argument at some point as to how that's applicable to painting, but go ahead.
Yeah, I have no further questions this week.
Either you got questions of this witness?
I let that approach right here. I'm sorry, I've never done this before.
Right there.
so. Mr. Samanak, are you familiar with section 9 of the lease agreement that we both signed, access to premises? So can you tell me exactly who within, you mentioned that there were multiple parties coming in and out of the private drive. What part of that is within section 9 as being agreed upon?
First of all, it's not a private drive.
Okay, so beside the point, access to premises. It says landlords or their agents shall have free access within reasonable hours to the lease premises for the purpose of examining or exhibiting the premises to prospective buyers or tenants, or for making alterations or repairs. Is there any language that states exactly what you had just specified about farmers coming in with equipment?
Says the landlord has free access.
To make
The landlord.
repairs, alterations, or to show prospective buyers. Were you doing any of that? Were they doing any of that?
For every document.
Hold on, you got one question, let him in.
Yes, Your Honor. Yes, Your Honor.
My other tenants should have free access also to that main driveway.
So was that written into our lease agreement? That for our awareness?
I'm sure you were told about it.
Okay.
You were told that the farmer would be coming through there,
So-
especially in the summertime.
In reference to the lease agreement, what we signed, can you tell me all of the evidence that's been shared about the access to the property? If any of those are within violation or accordance of the lease
I think
agreement?
what you're asking is, those individuals that are coming on and having access to the premises, do they fall within the parameters of paragraph 9? I think that's what you're asking.
That is what we're asking, Your Honor.
I believe they do.
How do they do that, sir?
Pardon me?
How does, in your own words, how do their access to the premises fall within paragraph 9?
Okay, first, okay. Access to the premises means the farm. The farm, this rental house is only one piece of the farm. The farmland is a piece, and there's several outbuildings there that are another pieces of the farm. So my people that rent the land from me and rent the barns from me have access through that main driveway. They do not have access to his house or that short driveway that goes from the main driveway to his house. That's the only part that's private for them, is that short driveway, about 50 foot long, from the main driveway up to this one car garage. That's the part that Travis did not seem to understand.
Well, hold on. So what's the address there?
The address of the house?
Yeah.
5867, is that correct?
Okay,
Sure, address.
so go to paragraph 1 of that lease. What did they rent according to the lease?
The house?
No, look at the lease. I get your interpretation, and you may have an interpretation of what they rented, but what did they rent? According to paragraph 1.
This is the premises known as 15867 Austin Road.
That includes that driveway. Right?
Do the barns have a different address, Mr. Sam?
Oh, ma'am, hold on. That includes that driveway. right?
If they have access to the driveway to the house, yes.
Okay, but that's the lease premises.
Barns are also part of the farm.
Well, that may be your other problem. Because under terms of paragraph 1, they lease that entire premises. Didn't they?
The understanding was at the time when we talked about it, is they lease a house and attached garage, that's it.
Paragraph 1, I understand what you're saying is the understanding. But paragraph 1 says precisely that they are renting the lease premises at 1587 or 867 Austin Road, right? Does anywhere in there say anything about the lease premises or about the house? Or let me put it another way. Does anything in the leasing agreement exclude anything on that?
Doesn't specifically exclude it, it doesn't specifically include.
No. That can be your interpretation of it, sir. You'll answer my question because the lease premises is that address, right? It doesn't exclude anything on that property. So it doesn't say, for example, that address with the exception of the bar. It doesn't say that, does it?
Doesn't say it accepts it.
Is there any other writing that excludes that's signed by both parties that excludes any part of that property? Go on to your next slide.
Your Honor, may I submit some evidence for the painting?
Okay, what do you have?
We have a listing that they had made to rent the house out, and all of the photos show the existing paint, showing that no painting has been done as of March
Yeah, it was-
23rd.
Yeah, the last update was May 23rd.
With no update of photos,
In the same.
but it shows the existing paint in the exhibits that they submitted to you.
Have you seen that, counsel?
No, I haven't. Today she has pictures, but
You have a copy. Let's provide it to you in another folder.
Do you have them?
Yes, he
Well,
does.
Do you have any objection to those photos?
I would object to, Your Honor, in that is something off the internet in May. And I think if they're supposed to be cross-examining this witness, why don't we ask them when they started the painting? Who put that on the internet?
His associate Melissa.
Well, hold on a moment. Hold on. Counsel, I gave you great leeway in terms of your questions that elicited hearsay. And now you want me to do that with them.
I guess we can accept.
Because, hold it. Because, counsel, if you want to play it that way, we can play it that way. Because here's the deal. Anything regarding that painting, they don't need to provide anything to you. Because all of that is hearsay. The bill is hearsay. All of that's hearsay, because I don't have anybody here. So if that's the way we want to do it, I'll strike all of that. I'll deny that being admitted. How do you want to do this, counsel?
You can have their pictures admitted as evidence, Your Honor.
That's what I thought. How many pictures do you have?
17.
That's 17?
We're just
Okay, so that's fine. That's fine.
16, 17, 18, Your Honor.
You have 18 pictures.
Yes, sir.
They're all from one source.
Yes, sir.
And they're all the inside of the house.
Correct.
All right, so here's what we're gonna do. We're gonna mark that all as one exhibit A, defense exhibit A. Did you have questions regarding that? Too?
I have no questions for that. Just wanted to state that it has not been done.
Got it. Well, let me follow up with that line of questioning. Sir, has the painting has not been completed? Has it been started?
Yes.
When did it start?
Exactly, about 2 weeks, 3 weeks ago.
So is the house currently being rented?
Your Honor, can I ask a question?
In a moment. Did you have any other questions of this witness?
Yes, sir.
Pardon?
Yes.
Go ahead.
I would also like to touch on the section 5 of the lease with paying the utilities. Mr. Samanak, it says that we must pay the propane no later than the 31st of December of the year the propane was purchased. Mr. Samanak, when did we move into this premises?
I don't know the exact date, you signed it on the 27th of December.
So it says that our lease agreement starts January 1st of 2023. And when was the first propane purchase for that house that you're claiming?
Propane that was in the tanks when you moved there.
Mhm.
Purchased in the summer of 22.
So according to section 5, Where in that language does that state that we owe that propane if we did not move into the 2023? Within the lease,
Well,
what does
hold
that
on,
state?
hold on. Her question is, where in that provision, sir, does it say that?
The only place it talks about propane is in section 5.
Okay, so the question then is, where does it state that they would be liable for what is in the tank before then?
Doesn't say in the lease, it's what they agreed to before they signed the lease.
Go ahead, ma'am. Well, hold on before you go. Sir, if you look at paragraph 5, right? The only propane that they would need to pay would be that which was purchased in the summer of 2023. Isn't that correct? That was a question.
They agreed to.
Sir, listen closely to my question. When I'm looking at paragraph 5, that paragraph basically says the only propane they need to pay for is a propane that would have been purchased in the summer of 2023. Isn't that what that says? Go on to your next question.
And Mr. Samanak, I wanted to reference the conversation we had in January regarding the reduction of rent. Was the stipulation not that we were going to read the meters and then pay the propane appropriately once we moved out on May 1st?
I don't remember you saying that you would pay them.
We agreed that we would read the propane meters and that we would figure out how much that we owed at the end of our lease. And were we given that opportunity?
Remember that conversation, although we did talk about reading the meters when you moved out.
Mhm.
And giving you credit for what was in the tanks.
Okay, and so with that being said, they paid up until February when we asked to have the readers met, and then we read, and then we'll pay you appropriately, because we did not know the amount that we owed. It was not clear due to all the handwritten letters we've gotten.
Got a question? Do a question. I don't need a
Okay. How would we know what we owed if we had not read the meters yet?
That point, you owned almost 100% of the bill, so there's a lot of it could have been paid.
According to section 5, we did not owe 100% of the bill. So how would we know how much we owed until we read the meters at the end of our lease?
You had to go by the numbers I gave you.
Correct.
And do you have a date when you would have given us those specific numbers? I know you referenced that there was a document. We don't have a document. So could you provide us with a date in January you would have done that?
I believe I gave you a copy of the bill. The propane was delivered in the summer of 23.
And then we obviously have made a $1,400 payment towards that, which you've admitted. So we have been paying on that. So when have we defaulted on paying the propane?
Now the bill's not paid yet.
Okay, we're in court. So,
Again, of
You gave
course.
us that for a month and a half, 2 months, and you haven't paid a nickel since.
But when did somebody give them a number?
When we made it.
I mean, outside of being here, when did they have a number?
Gave them a number.
we were served with court documents before we even moved out, stating that we owed that much money.
You gave them a number when they moved out.
Shortly after.
Where is the writing where you gave them the number they needed to pay?
It was in the original complaint.
Oh, ma'am, not the it wasn't directed at the defendant. When did you give them a number? Sir,
And the exact date in front of me.
did you give them a number in writing?
Probably in our first court hearing. After a very heated one-way conversation with Travis, he said he'll never pay another dime.
Okay.
Mr. Salmon, can I ask what time frame that conversation took place in? Was that the call we had in April after we had already satisfied all payments made to you?
Sorry, it's all that.
So can you reference the time frame that call was made in? Was it in April after we had already made all prorated rent and satisfied propane payments to you?
hold on, folks. What was the propane bill that was paid in, that you purchased in 2023?
Copy of it in the paperwork, there was approximately $1,700.
Okay. And they paid 1,500, right? Or their parents paid
1,400. 1,400, sir.
14, right?
Mom and dad paid $1,400.
Okay. So at most, then when I'm looking at the language of this contract, by December of 2023, they owe $300.
$1,400, paid $500 in December, $500 in January.
And I don't care when it was paid. Here's the problem that I'm having. The lease itself indicates that the only propane that they need to pay for is that which is purchased that year. So the $1,700 purchase in 2023 needed to be paid by, according to this, by December of 2023, they needed to pay whatever that bill was, right? Whatever this is the other problem with the agreement, because I'm not sure, according to the lease, that they would be required, well, a couple of things. The propane that was purchased in 2024, right? That they used.
There was no propane purchase in 24. It was bought in the summer of 23 and the summer of 22.
Okay, so all they owe then for propane is $300.
But we did not use all that was in those tanks, Your Honor. There's still 900 gallons left.
Well, yeah, that's a whole other issue, but. Okay, go ahead with your questions.
In January, when we had our phone call, me reaching out about prorating the rent due to the continued violations of the lease agreement that you had not acknowledged multiple times in our previous calls. Did I come to you on the basis of the violation of the lease agreement in reference to wanting to prorate the rent? Was that, I mean, can you confirm that that was the nature of our conversation?
Conversation, one side of the Jew screaming for about 15 minutes. That's all I decided to do. Let you go ahead and move on.
You have evidence, what you just said of me calling you every name in the book?
My wife heard it all. You slandered her, my wife, my kids, everybody around my family.
Okay.
Made bad remarks about it.
Okay, beside the point, the question that I asked you is, reaching out to you, was that not on the basis of the repetitive egregious violations of the lease agreement that you had acknowledged but not taken any action on?
You violated more provisions of the lease. Only thing I've done is I did not get that bathtub taken care of. I was unable to get it done. It's the only thing that I've done.
Mr. Samanak, in regards to that question, do you not recall the videos and photos we sent you of all the pest infestations?
I never got a video. My phone does not receive them. If you send them on the phone, I did not get them.
Do you receive photos? No.
No.
Okay. Was that ever communicated to us? Okay, for sure.
Go ahead.
I have no further
No
questions.
further questions, Your Honor.
All right, you may proceed. Any redirect?
I have no further questions on this purpose.
Sir? Is a house been listed?
No, it was put on Zillow for a few days by mistake. I was not,
By mistake?
yes.
How
The
did
lady
that,
that put it on was going to help me, and she thought misunderstood what I told her. And
she was gonna help you do what?
try and list the house for rent. And there was too many things that I needed to do, and I told her that I don't want to do it. She said, well, it's already on, so we'll take it off. She did.
When was that?
Sorry,
When was that?
don't have the exact date, but probably a week or two after they moved out. Moved out the 1st of May.
Do you have any pictures of the current status of the painting?
I can tell you the 3 rooms that were.
Do you have a receipt for the purchase of any materials regarding the paint?
Spent approximately $300 at Menards.
I'm gonna go back over these figures you're indicating your own. You're saying that they owe you $1,200 for May and April,
Each, yes.
total of
No,
24,
March,
20,
April.
March and April, $2,400.
Yes.
How much are you claiming for propane?
1,800 this one.
1859 or 1889?
Yes.
And then 293.66 for electric. Those are all your claims.
Those are the paint.
And the painting is how much? 17, how much?
I don't have the exact amount, but the labor is gonna be 17 or more.
What do you mean you don't have the exact amount?
They've already used up about 1,700.
Do you have a canceled check, anything that tells me that that's what you paid for painting? Pardon?
I do not have the answer.
How'd you pay them?
Give them credit. It's the only money.
Dear goodness. So the person doing the painting owes you money.
Yes,
And so they're supposedly doing this work and then you're going to take it off of their bill.
yes,
So there's been no outlay of any monies from you to a person to paint these premises.
yes.
And I don't have a bill for paint. I don't have a bill for any of that, right?
You have an estimate for the,
Whatever that is, I don't know who created that estimate.
I have a second estimate, it's higher than that.
I don't know who these, okay. It's not the way this works. You're telling me that it's 1,700 for that. But you haven't paid that. Well, that's not my question. You have not paid that, correct? You're saying that you bought supplies at Menards, but I don't have a receipt for that, right? So in reality, I have nothing here today that tells me anything about the painting, other than what you said, right? And so off of all of this figure, you do admit that there's a $1,200 security deposit.
Yes.
Any questions based upon the court's questions?
I have nothing really.
You may step in. Any additional witnesses for the plaintiff?
We have no further witnesses at this time.
Yes.
All right, before I hear from the defendants, and I don't know if I'm necessarily going to need to hear from the defendants unless for whatever reason plaintiff wanted them called, because folks, I don't mind coming back and making the ruling, but I think the parties should try to figure out if they can resolve this without screaming and yelling at each other, and I'll give that opportunity. Because there's some agreement to pay half the rent. One party's claiming it's because of stuff that wasn't done on the premises. The other saying it was continued upon this propane bill, which I'm not sure that propane bill is owed. Outside of that, whoever drafted this lease, and this lease, counsel, as I'm sure you're aware, any ambiguity in that lease is going to be construed as against your client. And so I think you need to look at that language very closely because it's his lease.
I understand.
And so there's that part of it. The other, and those ambiguities, just so that the parties are clear, are the premises that's leased and interference with that premises, because it got a problem in that initial paragraph.
But there's no part of that lease refers to anything in the way of quiet enjoyment and use of the premise.
Except by operation of law.
I understand.
I mean, even if it's not in there. Okay, well. So I'm going to tell you what, I'm going to try to handle some of these other cases. You guys, if you guys can talk to each other civilly, need to go out and resolve it. There's 1,200 sitting in a security deposit. I have a paint job that I'm not even sure is done or is going to be done. That isn't going to be paid. That somehow or another is on some credit. I've got property that they lease, which by the leasing agreement itself says they lease that whole thing. And then, goodness help us all, we have paragraph 5 which is the most confusing provision regarding the payment of propane. And if you guys want me to give you my decision on that, I'll be more than happy to. But I think you guys probably should see which way the wind is blowing, go out there and try to negotiate something. If not, you'll get my call on it. I'll break on this case. Everybody else that's waiting, you got to give me about 5 minutes. I will come back, I promise. Maybe. All right, court's gonna stand in recess.
All right. All right. 14A District Court, County of Washington, State of Michigan, is now back in session. The Honorable Judge J. Simpson.
You may be seated. So are they back yet? Nah, probably not. Okay. Are you guys ready on? Looks like Miss Maskell. She's all packed up and ready to roll.
My client just stepped out to get the other.
Which is your,
I'll grab her.
okay. Let me start with this one. Monica King versus Sarah Goble. Sarah Goble. Your name, ma'am?
Sorry, sir. It is Sarah Goble.
All right. And where are we on this case?
I know the court's familiar with both the situation and the case because you dismissed a prior case in terms of the non-payment claim. The rent now due is $4,800. The costs are $258 for a total of $5,058. But we amended our complaint to include a termination of tenancy case, and in neither circumstance is there a triable issue.
So yesterday I did apply for our DHS assistance, so I can at least try to get this paid. I do not owe all of that, Your Honor. I did say that last time. I'm going to say that again. All of this started over her assaulting me and me calling the police. This is the whole reason why this situation started. I am looking to move, and I am going to move. I just kind of want to make sure that all of this is taken care of. I don't feel safe living in her home anymore. She's
All right,
now, since
so-
school started, she's now shut off the Wi-Fi, which was supposed to be included in the rent. She is shut off. She shut the fuse off downstairs to the washer and dryer, so I know how to use the washer and dryer. She has taken the lock off the screen door, so I can no longer lock the screen door.
Judge, are we trying this case now?
I don't know what we're doing. Ma'am. But you want to move out.
I do want to look to move out, so I am asking that DHS help me get this paid, so that way I don't owe any money. I don't.
Well, this is a possession only case. I don't, they're not asking for a money judgment at this
Oh,
time.
I thought it.
So it's just a possession only case. So when are you gonna move?
By July 1st. Really, probably.
Today's what, 18? Okay.
The 10 days would be the 28th. I think the first, I think it's a Monday. Is that right?
First is a Monday.
So if we have a judgment with no redemption amount for the 28th and she's gone by the 1st, she will have satisfied the judgment.
What?
I have no idea what any of that means. Sorry.
Basically, there would be a judgment. There's nothing in this case for me to try. So first of all, so there would be a judgment. You want to move.
Yes.
They're not asking at this time for money. So it would just be fashioning a judgment for a move out date. And you would normally get 10 days. You said July 1st, you would normally get 10 days. I would make it the 28th, which would be 10 days, but that's a Friday. And so the 1st is that Monday.
Okay, sounds good to me.
Does it work?
Yeah.
Okay. Court,
Your Honor, I have
after hearing no tribal issue?
and I'll take out the redemption amount.
Correct. There'll be no redemption amount. We'll just do it as a termination. You'll move. That sound good?
Yes, sir. Thank you.
All right.
Hasn't done what had to come
Well,
back.
hold on. Well, hold on.
Oh, she
We're not quite done.
We can order the eviction.
had to come back.
Okay, so ma'am, the judgment here in front of me, they're not gonna put a redemption date, so basically it just means you're gonna move. And that you're gonna move by June 28th, 2024, which would be your 10 days. And I'm finding that based after a hearing on no tribal issue. Any questions you have?
So what them saying that I owe this money though, what is that really?
They would have to bring another claim if they're claiming that you owe money,
Okay,
but that's not, right now, that's not before me.
okay. And then the other question would be, with this being an eviction, will that, is this an eviction so that it'll go on my record? Is that?
It would, that there would, it would, I hate when people say it, their record, but what will happen is that it will show that there was a judgment entered
And
for
then
possession.
My question is, with her stating that there's all these other people in the home, is it gonna go, because that's my mother-in-law, my brother-in-law that don't live there, none of them live there, my husband, is that gonna go on them too, as well?
Well, the people that I have in the case are Sarah and Donald Goble
Mhm.
and Joshua Goble.
Yeah.
And Gladys Down.
Yeah, and that's what I don't understand, is why she has all these people that live in my home.
Are
She did that.
they in the premises?
No, sir, they were my guests here and there. That's my mother-in-law.
Your
I don't know
Honor,
how she got the names.
they have each been there at some time or another. Each has,
As
inter-
my guests.
ma'am, each has interacted with Ms. Goble. None of them has appeared in this court. We could make it a default judgment. If they want to ask for relief from judgment at some later point, we could discuss it, but each of them has been there, and I didn't want to be in a position where I had a judgment against Ms. Goble and someone else claimed possession. And so that's why I named them as defendants. They certainly knew about it, and at least one of them had a conversation with Ms. King about it, but we named them as defendants. If you want to make it by default for everyone except Sarah Gobles, that's fine.
That's
Just
what I-
want possession. And in response to her question, which you answered fine, but I'll just add that if she moves, we don't get an order of eviction.
That's right.
So again, if I'm,
Here's what I'm gonna do. They have not appeared. Okay, so it's gonna have the same net effect. But I'm gonna issue the judgment by default as to defendants 2, 3, 4.
Thank you.
And after a hearing, finding no tribal issue as to you. So if they, and I realize you might be sticking up for them, but if they want to do something about that, they'll have to file a motion with the court to get rid of it. Okay,
yeah, because we do plan on doing some, that's afterwards.
all right. Very good. I've signed it. Thank you.
Thank you, sir. Have a good day.
You do the same. Or calls the case of New Park Ridge versus Sakima Cooper.
Thank you, Plaintiff.
Lou Maskell here for Ms. Cooper.
All right, and this is your motion.
It is, Your Honor. We are here on my client's motion for summary disposition. If the court is ready, we can proceed with arguments.
Go ahead.
So it's our position that the notice that was provided to my client was vague and therefore didn't meet the statutory requirements and cannot be relied upon to confer subject matter jurisdiction to the court. Specifically under the HUD regulations, the state requirements found in MCL 600-5716, and even the lease itself requires that the termination notice must state the grounds for termination in enough detail for my client to prepare a defense. The notice itself merely says that there were physical threats and verbal abuse to property management staff. It doesn't cite the lease provisions that they're relying on. And as the court,
But what's the requirement for the notice to state that?
what's the requirement for the notice to state?
The lease provisions or whatever. I mean, because statutorily, because of the physical threats, they could file a notice to quit.
Well, Your Honor, they have to plead with, or they have to, in the notice, put enough detail in there so that the client can prepare a defense. And that would include, who was involved with the incidents, when they took place, where they took place, what was alleged to have happened.
In the notice?
In the notice. There's a higher standard for notice pleadings in subsidized housing than compared to private housing.
Right, but did she take advantage of the meeting?
She did have a meeting.
Okay, was that laid out? And that was prior to the filing of the complaint?
That's correct, Your Honor.
And were the details regarding what was complained about the physical threats discussed in the meeting?
The physical threats didn't happen, so that's why.
Well, I'm not,
I mean, question, but we
Well-
had the meeting the next, 5 days later, and
I think my client was certainly confused at the end of the meeting as to what was being alleged against her. And she, at the end of the meeting, also felt that, or was her impression that they were allowing her to stay, and was surprised by the fact that they had filed a case against her. By the end of the meeting, that was her impression that, I think they said, well, if you get your ducks in a row, you can stay, something to that effect. She believed that she was going to be able to continue to live there.
Mr. Frank,
So
go ahead. I'm sorry, Ms. Maskell, go on.
the other issue with the notice, Your Honor, is that they haven't specified in the lease, what lease provisions or what standard they're adhering to terminate the lease. So, if you refer to the lease, it says that they can only terminate in certain circumstances. One of those is material noncompliance with the lease. Another category would be good cause, and those are found in paragraph 22 of the lease. And good cause is also defined in several different ways in the lease. So they don't specify what exactly provision of the lease they're relying on. Merely just saying that there were allegedly some arresting. So it's our position really that they don't comply with federal or state laws about notice requirements in subsidized housing or even the lease itself.
Your Honor, I just have three things to say. The first is that even if what my sister at the bar alleged was accurate in terms of facts, that would not deny this court subject matter jurisdiction. That's the sole basis for this motion, 0.116C4, that you lack subject matter jurisdiction. We have litigated this issue before, albeit in a CARES Act case, but it's the same thing. We filed a complaint with a notice to quit and a copy of the lease pursuant to the statute. You have subject matter jurisdiction over summary proceedings. That's the first part. Secondly, the complaint itself alleges a violation of lease paragraph 12 and 22 and references the notice to quit. And third, if the defendant would like a more definite statement, you can order us to provide one and we will lay it out. Those are my three responses, Judge. I don't think I have anything else to say.
Anything else?
Yes, Your Honor, with regard to Mr. Fink's last point first, the reason that the notice itself has to include more specific details is it provides the tenants with an opportunity to decide how they want to proceed. Specifically, she may have decided to move out. She may have decided to, seek other arrangements. It's not appropriate to leave that all until a trial to take place before she can learn what the actual accusations are against her.
Well, but isn't that the reason really for the meeting?
It's the law requires it to be in writing, Your Honor. The meeting is a chance to discuss the terms, but she didn't even know what she was walking in to discuss when she came into the meeting, really, because it wasn't spelled out for her. The second issue I want to address, Your Honor, is the subject matter jurisdiction. Ypsilanti Housing Commission versus O'Day specifically states that if the notice itself doesn't comply with statutory requirements, that it's invalid. And then you couple that with Park Forest, and which says that you need a proper termination notice in order to have jurisdiction or hear a case. So those two cases together, the notice is improper. You don't have a proper notice. You don't have subject matter jurisdiction to hear the case. That's our position on the subject matter issue.
You're saying in O'Day it said what? I mean, I remember O'Day because I litigated it, but go ahead.
They found that there wasn't a proper notice in that case and that they were required to adhere to.
But the reason for the notice being improper was?
I mean, in that case, in that case, there was the 7-day versus the 30-day notice, right? And so they gave a 7-day notice, which I think was provided for in their lease, which didn't comply with
Which didn't comply with the state statute regarding, but complied with HUD regulations.
Right, which
then taught everybody to comply with state statutes and not HUD regulations, which this notice in this case complies with the state regulations.
I don't think I disagree, Your Honor, that it complies with the state or with the lease. So even if you find that it complies with the HUD regulations, I would say it still doesn't meet.
I mean, if the basis upon which you're saying that this court doesn't get jurisdiction and that the notice for that reason is improper, I think that the notice is proper. If the notice has to state certain things, it does that. To the extent that there is some, I guess, penalty or something that might adhere to or near to your client regarding this, I don't think that happens in this case. I mean, the 10 days to discuss it with management, she had those 10 days. I don't know what came out of the meeting. I typically don't know what comes out of the meeting, but they typically do that before such time as they do it. But as far as the particular provisions of the state and the conferring of jurisdiction on this court, I believe that the notice is satisfactory in terms of complying or conferring upon this court notice. I guess we'll say one thing. It's April 1st. So I'm going to deny your motion for summary disposition on those grounds. Now that there's a case before me, I guess I am a bit concerned as to at least what your client has indicated, that she's not sure of what the allegations are. And that there may have been, after this meeting, at least her impression that she may have been able to stay. And I don't know. Does she not know what the allegations are based after the meeting? Whether she agrees with them or not? Because one of the things that she said was, it didn't happen. Okay, well, that may have to be litigated as to whether or not it happened or not, but
Your Honor, I don't know what the allegations are, so I haven't been able to go over that with my client to answer your
Okay,
question.
got it. Okay.
Your Honor, what if we did a final settlement conference? It would give all of us a chance to be at the same place at the same time. And in the meantime, I will get as much information as I can and forward it to Ms. Maskell.
Well, I think. Yeah, I don't have a problem structurally with that, but I think there needs to be something more definite so that counsel can sit down with her client. It used to be at those meetings that there was something written that came out of it. I don't know that that was ever required, but I certainly can never.
I think there was something, but I was focused on this motion and the one reason for it. But are you ordering us to provide a more definite statement?
Yes,
By when?
with specifics in that. Guess I would like to see that before the end of the month, by the 28th. You do that? Well, you need more time than that?
Oh, Your Honor, I have an intern who is looking for substantive work to do and wants to impress you. So the 28th is fine.
We'll see.
Smiling, so
We'll see if the latter will happen. So you can get that to Ms. Maskell so that she can sit down with her client. I
and
guess.
then we'll do a final settlement. I don't need a response from Ms. Maskell to the more definite statement. I'm not saying she
Well,
can't file.
I am certainly she can, but I realize that if there is an issue, the two of you will talk. It's the parties that don't talk that bother me. So I'm sure there will be discussion that will go back and forth. And so if there's a necessity for you to file a response, certainly you can, Ms. Maskell. But what I then want to do is make sure that there's enough time for Ms. Maskell to do any investigation that she might need to do regarding those allegations, because she couldn't have a meaningful discussion either with the client or with you, Mr. Fink. So I would probably move it into the latter part of July.
Like the 22nd?
23rd. Why do you keep picking
23rd.
dates? The 23rd, that's a Tuesday. Did he ask you or he just started?
Oh, Your Honor, I always ask even when it doesn't sound like it.
Yeah. Okay.
What's going to be scheduled for that day, Your Honor?
I was going to set a final settlement conference for that day. If that is enough, what I was trying to lay out, Ms. Maskell, was if they get that to you by the 28th, you'd be able to have preliminary discussions, figure out exactly what it is, give you enough time to kind of at least do the preliminary part of any investigation into what the allegations are. And then I would have a final settlement conference on the 23rd of July.
I think
We'll work it
council
out.
has been willing generally to comply with any discovery request.
Generally?
That potentially and very likely there will be some discovery that's necessary after we get that 28th document. So that's my only
Right. And
thought about timing.
And here's what I also want to know. Is there a police report? Is there any outside agency that would have responded to any of this?
Not that we're aware of, Your Honor.
Mr. Fink?
I do not know.
Got it. Okay, that's fair.
I'll do a short order that says the motion summary is denied, that we're to provide a more definite statement by 6/28, and the parties are to appear on 7/23 at
9 in person.
for a final settlement conference.
Your Honor, one other issue,
Oh,
there
yes.
are a few outstanding maintenance requests. I believe I spoke with Jillian about it. I can forward those along to you. I'm asking that we work together to
You
get
want
those
you want him to do
requests. I would love for you to do them, Your Honor.
He's pretty
I would
handy.
do it. I would.
Oh, no.
And I expect that is not.
That's what it is. Plumbing and electrical I can do,
You
but
send them to Ms. Engen, we'll make sure they get to
Okay.
the client.
okay.
We're good. Thank you, Your Honor.
All righty. Thank you. They're back in. Cindy Lee versus Amanda Bevan.
Anything for the plaintiff? Your Honor, this is one that while Ms. Rosen and I also are very good at negotiating and communicating with each other, this one will require the court's assistance in what you generally call shuttle diplomacy.
Okay. All right. Then you guys have to give me a few minutes. I'm gonna try to
Thank you.
finish up my trial. What's the last?
It's Mr. Feets, but it's Miss Bowers.
Oh, do you know if Miss Bowers had to leave the courthouse and come back? Miss Bowers? Yes.
Also, Your Honor, she was doing a Zoom.
Oh, was she handling her matter by Zoom? She said she had something before Judge Barr at 10. I just didn't want her to feel left out, but I'll leave her out if I have to. All right. Court recalls case of Samanek versus Ockerman and Meltzer. All right,
I'll get my stuff out of Mr. Ellis's way.
all right. Were the parties able to try to talk at all, or do you guys just did?
Unfortunately, we cannot resolve the case, Your Honor.
All right. I think I understand defendant's position unless you guys wanted to testify about something. I don't think I need it necessarily to come to my decision. All right, closing arguments.
Your Honor, we have a lease agreement here that it seems as if both parties are having difficulties in interpreting that lease. But the lease is clear that changes have to be in writing. We feel that the testimony has been sufficient for the court to award a judgment for the unpaid propane. We believe the unpaid amount is $1,882, unpaid electric of $293, rent for 2 months, March and April, $2,400. And then we have the issue of the paint. If the court wants to disregard giving the plaintiff any money for repainting, as long as we got the propane money and the back rent and the electric utilities, we would be satisfied. There's no provision in the lease that says they're going to have quiet enjoyment or exclusive use of this premise. There's been no testimony given to the court as to why they should not pay the 2 months worth of rent. There was testimony that Mr. Samanek at one time said if they paid the propane, he would reduce the rent. The propane bill has not been paid. Even if you interpret the lease as saying that they only have to pay the propane bill on December 31st for propane that was delivered that year, there is still an unpaid balance of propane owing. So I would ask for a judgment for the expenses as we stated there. And then you could give them credit for the $1,200 in a security deposit.
Closing argument.
Your Honor, we do not feel as if we owe the propane due to the prorated rate of over 900 gallons still being in the tanks. With the $1,400 payment due, which would null and void his claim of the rent, which we have satisfied per our agreement in January. And we dispute the charges as well.
Your Honor, the entire basis for this was reaching out to the plaintiff in January due to multiple egregious violations of the lease agreement. The plaintiff has been unwilling to, and his attorney, to review the evidence, the severity of what's occurred and why we reached out in the first place in January to prorate the rent and facilitate an exit of the lease. In this case, we do not feel that we satisfied the rental payments in accordance with what we agreed to in January. That prorated rental payment was not predicated on propane payment in any way, shape, or form. Multiple parties were present for that call, and I would say that all of them can attest to the fact that nothing of that nature was said, nor did I personally agree as a party on the call to those terms, those verbal terms. So we do feel that we have satisfied not only the rent, but the propane requirements as well. We do feel that there's unaddressed matters with the violation of the lease agreement and why we had initiated all this in the first place, to recognize that there's a time and a place to address those matters as well.
And we move for our deposits to be paid back to us in full.
All right. Court has listened to the testimony, read the pleadings, and frankly, the defendant's position is rather straightforward. They acknowledge that they owe the $293, I think it was $293.66, which are the utilities. So that's the easy one. The next rather easy one, but the court's going to make its own finding on this, and that is that what both parties agree on is that for those 2 months, there was an agreement for basically a 50% rent reduction. One party says it's because of what were the conditions of the premises and regarding use of the premises, that being the defendant. And the plaintiff is indicating that the reduction came because of, or if the reduction would take place and the defendants were to pay the propane, but had somehow not done that. And so therefore he considered, as his words are, he considered the agreement void. I have to say, when the court analyzes that, the plaintiff's position makes no sense. I don't know why I would give a reduction in rent for somebody to pay me another bill or outlay in cash. That just doesn't make any sense. What I think is that there was some dispute between the parties, and the court would find that was more along the lines of what the defendant is claiming. And I find that their statement regarding that is correct. I don't believe that this propane was of such an issue that it would require the rent to go down. If one's not paying what in effect may be a utility, why would I reduce their rent so that they could pay me that? Again, that makes no sense to me. And so the court believes that for those 2 months that the defendants do owe $600 per month, but the $1,200 for those 2 months. I would indicate that, and I'll put it this way, my other reason for finding that regarding the reduction in rent is the same confusion that comes from the lease itself. The lease itself, this is why people should probably have attorneys draft leases for them in full and fully understand its implications, because that lease leases that whole premises. That whole address is leased. There. So there's that. So the court does believe that they owe that $1,200. Yes, ma'am.
Sorry, we did fulfill that in February when we paid January, February, March, and April to Mr. Salmon.
So you paid the $1,200?
We paid $2,400 to him for those 4 months and a 50% reduction.
Got it. Okay.
So we've already satisfied.
You already paid that. Got it.
The son-in-law Harvey Proctor came to.
I don't need to know all of that. Sorry, she answered my question. Are you two married yet?
3 months.
3 months you get married? So by that time, you're going to learn to keep your mouth shut after she speaks?
I'm getting.
I hope so. All right. Maybe you'll get it. All right. Would, so that I want to make sure I'm clear, does plaintiff agree that that 600 was paid?
Well, Your Honor,
I'm not looking for full argument. I'm just saying, did they pay the rate at 600 for those months?
but for those 2 months, but if you look back at January, the $600 in January forward.
I'll take that as a yes. I'm done. So I don't really need to do anything with that because I think that they fulfilled the 600. The plaintiff himself stated that whatever that agreement was, he just said they didn't fulfill and then unilaterally decided that they had breached the agreement. And so now is going to charge them. It can't work that way. And it won't work that way. And the court's not going to enforce that to happen. Particularly when now he's here attempting to try to sue for the propane that he wanted them to pay, which some of that, quite frankly, given the lease, they don't owe. Now comes the really, in this case, well, let me just deal with one other issue. So I've dealt with the rent. Quite frankly, I believe that the defendants have satisfied the rental provisions as outlined and as amended by the parties. As to the electric, they admit that they owe the electric, just so that we're all clear. In regard to the painting, I'm going to say this, and I'm going to try to put it as gently as I can. I have some issues regarding credibility from the plaintiff side. And the issue that I have regarding that credibility is that it was very clear that the court was led to believe that there had been some outlay of cash, and I will have my recorder go back, about payments that he made in the amount of $1,700. Not true. I don't have a receipt here from Menards. I don't know if that's paid, but I certainly have questions about the plaintiff's credibility to this court. It wasn't until later that it turns out there was no payment in part on this paint job, that it was credit because that person owed him. That's a whole different scenario than to say, I have paid this money. And I think it was quite honestly a direct attempt to mislead this court as to what was actually transpiring. And so I don't believe that plaintiffs owe anything for any painting. When I look at that provision, one of the ways to interpret that provision regarding alterations and decorations, and because of the last portion that everything then belongs to the landlord. If it were a decoration, decorations don't belong to the landlord typically. They belong, unless, well, until such time as they become a fixture to the premises, that's when they become the landlord's property. Otherwise, they could be removed by the tenant. So theoretically, under that provision, had they hung a painting in the place, it all of a sudden belongs to the landlord. I don't think that that's the intent. I also don't know what occurred with this painting, but doesn't really matter to me. I think, quite frankly, that the plaintiff lied to the court, or at least misled the court, or tried to mislead the court as to what he paid. And I'm having no part of that, and I'm not going to award any of the $1,700, anything for the painting in that regard. With regard to the propane. Propane amount, which is, and again, this is why people should have leasing agreements, it's looked over by attorneys regarding this. At least once a year, presumably, there is this purchase of propane. Now, I mean, it's rather clear. Propane shall be purchased by the landlords once per year and shall be reimbursed by the tenants as soon as possible each year, but not later than the 31st of December of the year propane is purchased. So I can understand what plaintiff intends to do or is trying to do with reference to that propane, but he's stuck with his lease. He's stuck with his document. He's negotiating parts. I mean, it's a very strange thing because according to the language here, I mean, I understand they measured it at the beginning. There's supposed to be this other credit at the end, whatever. The only thing by the terms of this lease, the only amount that the defendants would have to pay would be the amount paid in 2023. And they owe that. We can talk about credits, we can talk about whatever. None of that matters realistically, right? And the reason why this is a bad way to do it is because the next tenant is really the one that benefits from what you've done. That's part of the problem. But that next tenant also could have had a deficit to what you've done. The fact is you guys didn't use enough propane to make it even for you. That's really what happened. And maybe that's the risk in having this type of an agreement. I don't know if that was the intent of the parties. I'm just taking the plain language of what's there. That propane bill. So what they owe is just the propane and only the propane purchased during 2023. And that is an amount of $1,737.34. They paid $1,400 of that. So the net effect of that is, I got my math correct here, is that there is $337.34 owed. Whether you left propane in, what you had in, not part of what I'm looking at here in this case. So they owe the plaintiff that amount plus, Emily, you're going to tell me what my math here, $293.66. It's actually going to come to an even number. I hit one. Yep. So the plaintiff owes, or the defendants owe to the plaintiff $631 in utilities and propane. They have a security deposit. While I thought maybe there might be an issue with the doubling of the security deposit, they haven't complied with the part of the Landlord-Tenant Relationship Act regarding the security deposit in terms of the notification, the written notification, which can occur in different ways now, but the written notification of forwarding address. They may have known where, they may have known any of that, but I don't think that's been done, and neither do I think it's properly been pled, although it becomes an issue in the case. But 1,200 minus 661.
569.
569. All right. So the net effect of all of this, after hearing all of the testimony, is that defendants owe plaintiff $631. There's a security deposit of $1,200. The court's going to order that I won't put it in the form of a judgment. I'll put it in the form of an order that if not paid within what would be 15 days, that it would then become a judgment, which the defendants could enforce, that the plaintiff must pay to the defendants $569. That's the judgment of the court. Counsel for the plaintiff will prepare for it.
Okay, Your Honor, just so I'm clear on this now, there's also the cost of $190.
You have to prevail on your claim.
Pardon me?
I'm not going to award costs. I don't think you've prevailed.
Well, we have the filing fee, we have the service fee and the motion fee.
How much do you want it to cost, counsel?
So you're saying we're not entitled to the,
I am not awarding costs, but what do you have as the total amount of the cost?
we have,
Because quite frankly, I think, counsel, this matter should have been resolved between the parties somehow and or another, and has been an absolute waste of time
Your Honor,
for all parties.
I practiced law for 49 and a half years and I've settled every case that could be settled. These people thought they were over.
I don't care why, because I now rendered my decision, counsel. I'm just letting you know. I think it was a waste. I just think it could have been resolved somehow. How much are your costs, counsel?
The costs are $190 for service fee, motion fee, and filing fee.
Parties will split that cost in the case. You take $100 off of whatever I said is owed, and then we're done. So it'll be $469. I'm done, folks.
Can I ask a question? So sorry.
Probably not, but go ahead.
I just want to know, are we paying him anything or is he paying us?
He's got to pay you $469. If he doesn't pay it within 15 days, it will be transformed into a judgment that you can enforce.
Understood, sir.
Okay.
So that nobody has a judgment against. Thank you.
Thank you, Judge.
You're welcome. Lee versus Bevan. There's Mr. Fink. Where's Miss Rosen? Oh, there she is back there, hiding from me. Okay, hold on one moment. Was anybody able to find Miss?
Bauer is in the outside conference room, Your Honor, waiting for her case to be called in Judge Bauer's courtroom. By Zoom.
Pardon? Can you do what? Who are you? I think she is representing you. And so what would you like me to do? Well, I'm looking at you, but you mean call your case? You have an attorney. It would be unethical for me. It would be unethical for me to call the case when I know you have an attorney. You know what? You can go out there and tell Miss Bauer, tell Miss Bauer that you fired him, then you come back in and you can represent yourself as soon as she lets me know. Court's going to stand in brief recess. I'll come out and deal with Ms. Rose and Mr. Fink. I will deal with you in a moment. You don't want to deal with me right this second. Court stand in recess.
All rise. And see. One second. All right, sir. All right.
Stop.
Week.
Commission is now back in session. The Honorable.
All right. Okay, in the Lee versus Devon matter.
Being taken to plaintiff.
Yeah, Rosen on behalf of the defendants.
And also Thomas Miller. What we have, we've had we've had a settlement conference. I think we've resolved some issues. And coming back, this matter may have to proceed a little bit further. But the court's understanding is that the plaintiff will provide extermination services to the unit within the next week and a half, somewhere around there. The utilities, the divide of the utilities still has to be decided. I have noted for the defendant that although the lease would allow it to happen, the plaintiff hasn't been charging for water or Wi-Fi. There's an agreement between the parties that rent beginning July will be adjusted to the $1,500 per month. then a decision will be made as to what the rent on the, well, it will be, is the amount that will need to be placed in escrow beginning in July. There is a possibility the court reserves the right to release a portion of the escrow to the plaintiff to be able to maintain care of the property. The defendant will be placing into escrow May's rent and the estimated, or actually maybe actual utilities of $564, basically to date, I guess, at least as to billing. And
By what date, Your Honor?
By-
What date should they place it in escrow?
how soon can they do that? Within a week? Can you do that?
Thank you.
And then the only other issue that I have here is that the defendant has agreed to move I guess it's a garbage can off of the grass and put it on another surface. That's all that I have, counsel.
Your Honor, I am going to send an email to the attorney representing Ann Arbor Township. I'll copy Ms. Weidling and Ms. Rosen, giving a summary that we've all agreed we'd like them to stand down until the defendants have an opportunity to move out.
Okay, very good.
Thank you for your time, Your Honor.
Not a problem. And
In order?
yes, if we could.
We'll take care of it.
Okay. That's you, but I'll do it.
Wait, he's looking at me. You do it?
Yeah, I'm gonna draft the order. Mr. Fink is doing orders all over the place because he doesn't have. All right, and we'll kick this out to July 23rd, 2024 at 9 a.m. And court does call the case of Hamilton Crossing versus Tiffany Peters.
Okay, take the plaintiff.
I have before me an emergency order to stay.
Yes, Your Honor, and I'm asking, I don't know if we need it now that we're getting to hearing. We're the other part of my motion was to set aside a default judgment,
Yes,
so I'm just gonna argue that.
okay, that's fine.
Your Honor, Ms. Peterson did not appear for the hearing on April 12th because in between the complaint being filed on, I believe, March 12th and the date that the March 11th, I'm sorry, Your Honor, and the date that the default judgment was entered, she was offered a last chance letter by the landlord that they both signed on March 28th. So she thought the issue was resolved, and that's why she didn't appear. And I have a copy of that for Your Honor if you'd like to look at it.
Last chance agreement. I thought it was included. I know I read that.
Yes, I did attach it. to
The
my
motion, yes. I think I saw it. All right. Okay,
And so that's why she did not appear. And then as far as
that was on the 29th. Was that the day you actually signed it?
it appears to have been signed on the 28th of March.
March. Okay,
And Your Honor, additionally, Ms. Peterson does have significant mental health issues. And so even though I think it's fairly reasonable for her to assume that she doesn't need to appear in court anymore on the eviction case after this has been signed, I think she was also confused about if she did need. That was not clear to her.
Mr. Fink.
Your Honor, they signed the last chance agreement on the 28th. On the 29th, we had court and the case, and Ms. Peterson appeared, and the case was adjourned to the 12th for the purpose of setting out a COD with the court. And we prepared one. And by the way, the COD would have included a provision that she moved by May 1st, but she didn't sign the COD and she didn't come to court. And so she was told after she signed the last chance agreement, she needed to come back to court and that there would be a COD. And she didn't show up for court. And so we took a default judgment. 8 weeks later, this motion is filed, 56 days. And while my client is always willing to give a soft landing, and we can probably work something out on the writ date, there has not been good cause nor a meritorious defense to the case established that would require, or I won't say allow because I know better, but would prompt the court to set aside the default judgment.
And I have, the reason that I waited to file is because I monitored the court to see if a writ was filed because Ms. Peterson, I connected her with SOS Relocation Services, and they've been diligently working on finding her a new place. But what happened is she and Grace at SOS thought that Ms. Peterson had a voucher for a 3-bedroom. And then when they got down to the end of the process, they found out that she only had the voucher for a 2-bedroom. So they had to start over. And then we had to get her voucher extended and all of that. So she is willing to move, but I just don't want there to be a time of the opposite of overlap where she and her 2 kids are unhoused, even though she, you know, has a voucher and is willing to move. And I will say also that the incident that caused all of this to happen was in December. And in the interim, she's been court ordered to be medicated, and she is very I've seen her when she's not medicated, and I've seen her when she is, and she's very different now that she's medicated, and she is able to make good decisions and such. So she hasn't, I mean, they did offer her a last chance letter, and she has complied with it. I don't know the purpose of offering this the day before a court hearing where they still want to evict her. And I don't know that she understood the inner workings of how all of that was going to fit together. And even if she understood it when she was here, I know that from working with her that she gets confused. She missed, I'm sorry, one more thing. There was another court date that she missed around the same time as the second court date here. So I think she may have been having a difficult couple of days in tracking her responsibilities.
In the last I knew about that other court date, that was the criminal case for the event that caused her to receive the notice to quit. The last time I checked, and I'm not saying this is true now, but the last time I checked, she had failed to appear and there was a warrant out of 14-2.
And I brought that to her attention, and I believe that she called the court to declare the warrant.
Did you get that taken care of, ma'am, or? Okay, all right, listen.
I will contact every 3 days on the week. I take medication. I have 2 young boys that I have to tend to.
Okay, listen. Okay, hang on a second. When you leave here, go right next door to the public. Were you represented by the public defender's office at your court hearing? Do you know? No, for the.
I didn't even know nothing about it.
Okay. Do this. You see anything?
At 14A2, she failed to appear for the arraignment pretrial, so she's not yet represented.
Okay, she can still probably get help from them. So I'd ask you to stop next door out here. That's the public defender's office. Tell them I sent you there, that you got a warrant out of 14-2 in Ipsy. Okay, and that you need some help getting that clear. Okay, because what I don't want to have happen is I understand you got a lot of stuff. I don't want you getting arrested on that. Okay, so you need you to do that. They're just right next to the this court. Okay, what I'm inclined to do on this case, counsel, do you think that a move out date can be worked out for your client? Where with the voucher process the way you have it now?
I just found out this morning that they extended her voucher to June 30th, which is really tight. What I was going to ask Mr. Fink for was to just work with us as long as she diligently works with SOS to relocate. Just let that process play out. But if she can't be out by July 1st, to not evict her. And I'm in contact with SOS on almost a daily basis.
So they've extended her to June
30th.
June 30th is her voucher. Oh, okay, so got it. When's my next? Not the 23rd. 16th. All right. Let me adjourn this out to the 16th of July.
Thank you, Your Honor.
Your Honor, is the order of eviction in the hands of the process server?
It is not. I did not sign.
July 3rd, is that what I heard?
July 16th,
July 16th.
2024. All right.
Yes, I'm available that day.
All right. Real good. So thank you, folks.
Thank you.
Thank you.
Have to run because.
All right. Ma'am, did you, what is that? Oh, ma'am, we just printed you out the ROA, our case management system. So when you go next door, show them that, tell them you got a warrant, you need help getting it cleared. Okay, and if you have to, tell them that Judge Simpson sent you over. Thank you.